Welcome to all. As a part of the course on insolvency and bankruptcy law in India, today we are going to discuss on the topic SICA, SIC Industrial Companies Special Provisions Act 1985. Famously, it is called as SICA Act. Let us discuss what we have discussed in the previous classes. Let us recap. So, in the previous class, we have discussed the provisions under the Companies Act 1956. Before that, we have discussed the Presidency Zone Insolvency Act and Provincial Town Insolvency Act and the insolvency provisions in UK and US. Okay. So subsequent to that, we have discussed the Companies Act 1956. So under the Companies Act, we have discussed the provisions relating to liquidation under the Companies Act 1956, and we have discussed various modes of winding up. So under the Companies Act, we are having two categories of winding up. So one is voluntary winding up and another is compulsory winding up. Then we have discussed about the grounds of winding up. Then we have discussed about who can file a petition for winding up. So members, creditors. Okay, so central government can file a petition for winding up. Okay, then we have discussed the provisions relating to appointment of liquidator and voluntary winding up of the company. Now let us discuss about SICA, SIC Industrial Companies Act. So if you observe the preamble of SICA, okay, so the preamble of the SICA provides the objectives of the SICA. So why this legislation was framed? So if you observe the preamble, an act, it is an act to make in the public interest special provisions with a view to securing the timely detection of SIC and potentially SIC companies owing industrial undertakings, the speedy determination by the board of experts of the preventive, ameliorative, remedial and other measures which need to be taken with respect to such companies, and the expeditious enforcement of the measures so determined and for matters connected therewith or incidental thereto. So if you read the preamble, I can tell you that you can understand the basic gist of the legislation, why this legislation was passed. Okay, so this legislation was passed with a view to securing the timely detection of SIC and potentially SIC companies. So one of the basic objective of SICA is to detect the SIC companies and potentially SIC companies. So that's why if you observe the provisions of the act, okay, so the board of directors of the company, they are having responsibility when any company becomes SIC. Okay, when any company becomes SIC, the board of directors are having responsibility to refer the matter to BIFR. Okay, so under this legislation, board was established, that is BIFR. So to the board, they are supposed to recommend. So once that is recommended within the time framework, though there is no prescribed time limitations are not there. So unlike in the case of IBC, Insolvency Bankruptcy Code, we are having the time limitations. Okay, so in the subsequent lessons we are going to discuss the timelines under the IBC. Separate lesson will be there, but under the SICA, okay, so the basic objective of SICA is to detect the SIC companies or potentially SIC companies, and whenever there is a possibility, you have to rehabilitate the SIC companies, or if there is no possibility or if it is not viable to continue the company, in such cases, okay, so the board will give the order for winding up of the company. Okay, so if you observe the preamble, from the preamble only you can understand the basic scope and the objective of the legislation. Okay, so look at the preamble. Okay, so remedial and other measures which need to be taken with respect to such companies. Okay, so preventive, ameliorative, remedial or other measures. So there is a possibility under the SICA. Okay, so if the matter is referred to the BIFR, the board, then they may go for revival of the company, and they can go for sometimes merger, amalgamation or any kind of arrangements under the Companies Act. Okay, or any other person can take over the company, or else if all the possibilities are not possible, I mean if revival of the company is not possible, in such scenario, the board may recommend for winding up of the company. Okay, so that is the basic objective of the legislation. Okay, so you can understand the objectives of the legislation from the preamble of the legislation itself. Let us look at the objectives. So one of the basic objective of legislation is identification of sickness. So we'll discuss the definition of sickness in the subsequent slides. So identification of sickness is one of the essential condition. Okay. Then registered not less than 7 years. Then the onus of reporting sickness at the stage of erosion of 50% or more of the net worth is on the board of directors of the company. So which says that whenever in any company, okay, 50% or more of the net worth is erodes or it is evaporated, okay, then in such cases it is the responsibility of the board of directors to recommend such matter to the board under this legislation, that is BIFR under this legislation. Then another objective of the legislation is BIFR, establishment of BIFR and establishment of appellate authority. Okay, so first objective is identification of sickness. Second objective is the board of directors of the company are having responsibility to inform or to refer the matter to the board whenever 50% of the net worth is erodes, and establishment of the BIFR and establishment of appellate authority. Now let us look at the key definitions under the legislation. First important definition is SICA industrial company, which is defined under section 2 clause O. So what is SICA industrial company? An industrial company having at least 5 years of existence which has accumulated losses equal to or exceeds its entire net worth at the end of the financial year. So please remember, whenever if I want to call any company as a SICA company, one of the essential conditions is that the company must be in existence for at least 5 years. So within 5 years of the incorporation, you cannot call the company as a SICA company under this legislation. Okay. So if you want to call any company as a SICA company under this legislation, at least 5 years must have elapsed from the date of incorporation of the company. So that is one condition that you have to remember. And another condition is that it has accumulated losses, okay, so which is equal to or exceeding the entire net worth of the company. So if it is exceeding the net worth of the company 50%, then in such cases, losses are exceeding the net worth of the company, then in such cases such company is called as SICA company. Okay. Then BIFR, that is Board for Industrial and Financial Reconstruction. So what is this BIFR? BIFR is a body, that is body corporate established under the act to determine the sickness of industrial companies. Okay, so and devise revival and rehabilitation plan. So from the definition itself we can understand that BIFR is a body like which is having the separate legal entity, and the basic function of the BIFR is determination of sickness of the industrial companies, and they are going to devise the revival and rehabilitation plan. So majorly wherever it is possible, first they have to propose a revival or rehabilitation plan. If revival or rehabilitation plan is not possible, is not viable, then in such cases you have to give the order for winding up of the company. Then appellate authority, okay, appellate authority for industrial and financial reconstruction, AIFR. The appellate body to hear appeals against the order of BIFR. So if any person is aggrieved by the decision given by the BIFR, that is Board for Industrial Financial Reconstruction, then they can go to the appellate authority, that is AIFR. Now let us look at the applicability. So this legislation, that is SICA legislation, is applicable only to industrial companies as defined under the Industrial Development and Regulation Act 1951. So there is IDR, that is also called as IDR, Industrial Development Regulation Act. So there is a definition is there for the industrial companies under the IDR legislation. So this SICA Act is applicable only to the industrial companies as defined under the IDR Act. Then please remember, this legislation is only applicable to companies registered under the Companies Act. So the entity must be registered under the Companies Act. If the entity is not registered under the Companies Act, then that is not covered by SICA Act. Let us look at some key provisions. Section 4 of the Act speaks about the establishment of the board. As already we discussed, BIFR. So under this legislation, BIFR was established. Okay. So the central government shall establish the board, namely called as BIFR, through official gazette. Okay. So they are going to notify in the official gazette. So by notification in the official gazette, they are going to establish the board called as BIFR. Okay. Then what is the composition of BIFR? The board shall consist of one chairman and not less than two and not more than 14 members. Okay, so the board shall have one chairman and minimum 2 members, and which can extend up to 14 members. So you can have maximum of 14 members but minimum 2 members. So one chairman, 2 members are required. Okay. Then constitution of appellate authority. So under section 5, if you observe, okay, so it is speaking about the constitution of appellate authority. So this is also one of the objective of SICA Act. So CG shall constitute appellate authority for industrial and financial reconstruction. So what is the composition of appellate authority? The chairman, one chairman will be there. Okay, so what is the eligibility condition for chairman? The chairman shall be a person who is or has been judge of Supreme Court, or who is or has been judge of High Court for not less than 5 years. So who can be the chairman for the appellate authority? Supreme Court judge. Okay, so either Supreme Court judge, or else if High Court judge is appointed, then he should be High Court judge for a minimum period of 5 years. Okay, so as a High Court judge, he should have the experience of 5 years, or else he should be a Supreme Court judge. Okay, so Supreme Court judge, or he was a Supreme Court judge. Then in such cases, such person is eligible to be appointed as a chairman for appellate authority. Then who can be the member? Who is or has been. Okay, so maybe existing or has been previous. Okay, has been a judge of High Court or officer not below the rank of secretary to the government of India. So who can be the member? So if someone wants to be a member in High Court, or someone wants to be a member in the appellate authority, then he should be a judge, maybe acting judge or previous former judge. Okay, an officer not below the rank of secretary to the government of India. Then they are eligible to be appointed as members in the appellate authority. Then section 15. Reference to BIFR by the SICA company. So this is another one of the important section under the legislation. Okay, so reference to BIFR. So where an industrial company has become SICA industrial company, the board of directors of the company shall, within 60 days from the date of finalization of the duly audited records, possibility is there even before the finalization of the company for the financial year, as at the end of which the company has become SICA industrial company, make a reference to the board for determination of the measures which shall be adopted with respect to the company. So if you observe section 15, okay, which clearly provides that it is the responsibility of the board of directors, okay, so within 60 days from the finalization of the duly audited records. So in case of company, the company has to close the books of accounts on 31st March of every year. So once the books of accounts are closed, then they are going to prepare, okay, they are going to prepare the accounts, then subsequently they are going to place it before the general meeting, at the general meeting. Okay, at the general meeting they are going to adopt and they are going to finalize the books of accounts. Okay, they are going to adopt it at the general meeting. Generally, as per the Companies Act, you are expected to conduct the general meeting before 6 months, that is within 6 months from the closure of the financial year. So before 30th September of every year, you are expected to conclude the AGM, or you are expected to conduct the AGM within 6 months. Okay, so when you finalize the duly audited financial statements, so from that date onwards, within 60 days. Okay, so if the board of directors are of the opinion that, okay, the company has become SICA industrial company. So what is the meaning of SICA industrial company? Okay, so SICA industrial company means, okay, your losses are exceeding or which is equal to, okay, either your losses are equal to or your losses are exceeding your net worth. Okay, then in such cases, such company is called a SICA company. So if obviously board of directors will be knowing, okay, so if the board of directors found that any company is a SICA company, okay, within 60 days, you are expected to refer the matter to the BIFR. Possibility is there even before closing the financial statements also. Even before closing the financial statements also, if board of directors are of the opinion that the company is getting the losses and such losses are equal to or more than the net worth of the company, then in such cases, under section 15 of the Act, the board of directors are having a responsibility to refer the matter to the BIFR under section 15. Now let us look at the section 16. Inquiry into working of SIC companies by BIFR. Okay, so under section 16 we are having the provisions where once the matter is once the company is referred to the board, that is BIFR, by the board of directors of the company, then in such cases under section 16 the board, okay, that is BIFR, will inquire into the working of SIC companies. Okay, so is it working properly or not? Okay, then whether is there any requirement to appoint another person to run the company. So all these things will be verified by the board. Okay, then under section 17, okay, so we are having the provisions relating to preparation and sanction of scheme for the revival and rehabilitation. So once the inquiry is conducted under section 16, then subsequent to the inquiry, the board, along with the help of the board of directors of the company and also other professionals, okay, they are going to prepare a scheme. Okay, the scheme can be for the revival of the company and rehabilitation. Okay, so what they are going to do, the board shall, after considering all the relevant facts and circumstances of the case, decide as soon as may be by order in writing whether it is practicable for the company to make its net worth exceed the accumulated losses within a reasonable time. Okay, so it is the responsibility of the board. When I am using the word board here, BIFR. Okay, so in case of board of the company, I'll use the word board of directors. Okay, so in case of board of the company, I'll use the word board of directors. In case BIFR, I'll use the word board. Okay, so here the BIFR, after considering the relevant facts and circumstances of the case, because already under section 15 already it is referred. Now they are having the financial statements and everything about every detail about the company. Then after considering all these things, okay, then if board is of the opinion that, okay, so if it is practicable for the company to make net worth exceeds the accumulated losses. So what was happened actually previously, you are a SIC company. When you are a SIC company, when your losses are equal to net worth or losses are more than the net worth. Okay, now your losses are more than the net worth or your losses are equal to net worth. Now what we are saying under section 17 is, okay, if it is practicable for you to increase your net worth, okay, or to reduce the losses otherwise, okay, to reduce the losses, okay, whereby your net worth is more than the losses, okay, if it is practicable, then in such cases please you are supposed to prepare a scheme for the revival and rehabilitation. Okay, then the board may give such time to make its net worth exceed the accumulated losses. So to happen this, okay, so why? Because now your losses are more than net worth or else your losses are equal to net worth. Now to ensure that your net worth is more than the losses, okay, so obviously you need to have some time. Okay, so you need to run the business, you need to have some time. So for this purpose the board can give some time to ensure that the net worth is exceeding the accumulated losses. So under section 17, so the board is having power to approve the scheme for the revival and rehabilitation and also to happen this. Okay, so there is a requirement to happen this, we need to give some more time. So under section 17, okay, so they can approve the scheme and also they can give the time to happen this. Now let us look at section 18, preparation and sanction of scheme. So what can be there? So as already we have discussed under section 17, okay, the board is going to sanction the scheme. Then how to prepare the scheme? So under section 18, okay, so we are having detailed provision is there. So the operating agency specified in the order shall prepare as expeditiously as possible and ordinarily within a period of 90 days. So as already I told you that once the matter is referred to the board, they are going to appoint the persons. Okay, so that is operating agency. This operating agency, they shall prepare within a period of 90 days a scheme with respect to such company, providing for any one of the following measures. Okay, so they may go for, okay, so they are going to propose a scheme within a period of 90 days. Maybe you have to close down the company, or else maybe you have to merge the company with another person, maybe another company. Okay, maybe you have to go for merger, amalgamation. Okay, so like the various permutations and combinations can be possible. So such permutations and combinations can be referred or can be proposed by the operating agency within 90 days. So what they can propose? They can propose the financial reconstruction of SICK industrial company. So you can concentrate on the financial reconstruction. Maybe you can raise further capital. That is also possible. Or else you can convert the existing debt into equity. Okay, so like that you can have various permutations and combinations whereby you can go for financial reconstruction. Then the proper management of SICK company, industrial company, by change in or takeover of the management of SICK industrial company. So the operating agency is of the opinion that the existing management is not working properly. Then in such cases, they may recommend to change the existing management. Okay, so they may recommend to change the existing management, or else other management may take over. That is, other company may take over this existing management of the SICK company. Even that is also possible. Then the amalgamation of SICK company with other company. So you can amalgamate the SICK company with another company or any other company with the SICK company. So possibility is that sometimes with the SICK company you can merge another company. So this is also called as reverse merger. Generally, loss making company will be merged into profit making company. That is a general tendency. But there is another possibility is there whereby profit making company can be merged into loss making company. Generally, it is called as reverse merger. Okay, so the operating agency can propose even reverse merger also, whereby it is a SICK company. Now other company is merged into SICK company. Even that is also possible. Then they can propose the sale or lease of part or whole of any undertaking of the SICK industrial company. So they can propose to sell or lease the part of any undertaking. Maybe the industry is having good property. Okay, so maybe that is located in prime area. So instead of keeping in idle, maybe you can propose to lease the property. Okay, so they can propose the sale or lease of a part or whole of any industrial undertaking of the SICK company. Okay, then the rationalization of managerial personnel, supervisory staff, and workmen in accordance with the law. So sometimes even the operating agency can propose HR issues also. There is human resource management issues whereby they can rationalize the things. Okay, so instead of having so many people, maybe you can try to reduce the workforce, or else it is like reorganization. Okay, so I cannot say that always it is only reducing the workforce. Okay, so maybe you can utilize in a proper manner. Even that is also possible. Then such other preventive, ameliorative and remedial measures as may be appropriate. So depending on circumstances, you can propose anything in the scheme. Okay, then such incidental, consequential or supplementary measures as may be necessary or expedient in connection with or for the purpose of measures specified in clauses A to E. So if you observe previous things, that is sale, maybe you can go for sale, maybe you can go for rationalization of managerial personnel, or else if you look at the previous slide, you can go for merger and you can change the management and you can go for financial reconstruction. Okay, to do all these things, maybe some incidental things are also possible. Okay, so you are expected to do some incidental things also. Okay, so all these things, maybe let me take one example. Okay, so you are going for financial reconstruction. Okay, so when you are going for financial reconstruction, maybe you have to increase the authorized share capital. Okay, so if you have to increase the authorized share capital, obviously you are supposed to alter the MOA, existing memorandum of association. So these things can be recommended in a scheme. Okay, then Section 19, rehabilitation by giving financial assistance. So there is another possibility. You can give the financial assistance also to the SICK company so that they can revive. Then Section 19, winding up of SICK industrial company. So under Section 20, okay, so the board can give the order for winding up. Then under Section 22, suspension of legal proceedings and contracts during the period. So this is nothing but moratorium period. So under Section 22, so once the company is admitted or once the company is referred to the board, okay, when SICA Act was implemented, I mean to say it is referred to the board and the board is taking care of that. Then during that period, okay, no legal proceedings can be there against the company. Okay, so it is like it will act as a moratorium period whereby no suit can be filed against the company during the inquiry period. Okay, now let us look at the repeal. So SICA was repealed by SICK Industrial Company Special Provisions Repeal Act 2003. But please remember, though it was passed in the year of 2003, but repeal act did not came into enforcement till the 2016. Okay, so when after implementation of the IBC, okay, so insolvency bankruptcy code only, SICA was repealed. Okay, till that time SICA was there actually. Okay, then what is the present status? Okay, the functions were transferred to NCLT under the insolvency bankruptcy code 2016. So previously BIFR was there, then you are also having appellate authority. So the functions of BIFR right now were transferred to the NCLT under the IBC. Okay, then appellate authority, anywhere right now we don't have the appellate authority. Now we are having under the IBC, NCLT. Above that you are having NCLAT. Then if you are agreed by the decision given by the NCLAT, then you can go to the Supreme Court. Okay, so NCLT, NCLAT, Supreme Court. So this is a hierarchy under the existing IBC. Okay, so SICA was repealed, please remember. Then let us discuss few notable cases. Okay, why these are all important? Though SICA was repealed, but in the subsequent lessons we are going to discuss and we are going to learn about IBC. Okay, so SICA was basis for IBC because SICA failed to redress the SIC companies or redress the issues within the time framework because we don't have proper time framework under the SICA. So that's why, okay, we learned the lessons from the SICA failure. So that's why now we are having IBC. So that's why it is essential for us to know about the SICA. So that is one of the reason why we are learning in this lesson about the SICA. Okay, so let us discuss few judgments. Okay, so in the case of Real Value Appliances Limited versus Canara Bank, the Supreme Court held that the moment a reference is registered with BIFR, production under section 22 applies. So as already we have discussed, under section 22 moratorium provision. Okay, though they have not used explicitly the word moratorium, but you cannot file a case against the company. Okay, once the company was referred to the BIFR, no one can file a case against the company. Okay, so once the reference is registered with the BIFR, then immediately the protection under section 22 will be applicable. Okay, then in another case law, Rama Narang versus Ramesh Narang, okay, 2006 judgment. Okay, so please remember where it was clarified that, so though under section 22 we are having moratorium, that is you cannot file a case against the company, but criminal proceedings are not barred. Okay, so it is only for the civil cases. So please remember SICA is civil in nature. So that's why all the civil proceedings are barred against the company, but criminal proceedings, okay, are not barred. So in another case law, NGEF Limited versus Chandra Developers Private Limited, it was held that BIFR is a final authority for deciding the matters concerning the SIC company. So once the decision is taken by the BIFR, that is final. Okay, so unless there is procedural lapses are there, unless legal issues are there, generally you cannot go for an appeal, okay, against the decision given by the BIFR. Okay, the decision given by the BIFR will be final. Okay, so let us recap what we have discussed in today's lesson. In today's lesson, we have discussed about the objectives of the SICA. Then we have discussed the key definitions like SIC industry, SIC company, etc. Then we have discussed about the applicability of SICA. So this is applicable to the SIC industries, industrial companies under the Industrial Development Regulation Act, and also the company must be a company registered under the Companies Act. Okay. Then we have discussed about the establishment of BIFR. Then reference to BIFR by SIC company. So we have discussed that it is the responsibility of board of directors to refer the matter to the BIFR when they found that the losses are equal to or exceeding the net worth. Okay. Then preparation and sanction of the scheme. So the operating agency is going to prepare the scheme and subsequently it is going to be sanctioned and they are going to implement the scheme. Then rehabilitation of SIC companies. So we have discussed about how they are going to go for rehabilitation. So while in the process of rehabilitation, they can propose maybe merger, amalgamation, takeover, changes in the management. So anything they can propose. Then if revival is not possible, then in such cases BIFR can give the order for winding up of the company. So this is last resort. Please remember, if revival is not possible, revival is not viable, then only we can give the order for winding up. Okay, so winding up of the company must be the last source. Okay, so unless you try all other measures, okay, you cannot go for winding up of the company. Thank you.